the access to those records, for example, isn't used as sort of a backdoor way of getting information that could not be obtained simply by subpoenaing you to appear at a deposition. So again, this is a situation where technically in the law it is a fairly narrow thing, privilege, but it has been interpreted to encompass a lot more than that, and that's really because of an acknowledgement both by the legislature and the courts in Washington that it's crucially important for victims of domestic violence and sexual violence to have the ability to get access to services without fearing that whatever they disclose in order to get those services will then be used against them in some way.
That's great, and I gotta tell you, I love the idea of being incompetent to do something. I'm gonna start using that. I'm incompetent I can't pick up my kids anymore. I'm incompetent to do it. I like that. So, and you kind of just said this. I don't know if you have more that you wanted to.
Yeah, and so this is really, it's important to think of it in the context, I think, of, we all sort of intuitively know, I think, why it's important that to our clients on a general level that they be able to feel secure and that their privacy will be protected. But one other way of looking at it is to think about it in terms of people like doctors. Doctors, just like advocates, have a privilege. It has slightly different exceptions, but some of them are similar. But in the context of medical privilege, if you go to your doctor and you're afraid that if you disclose that some injury that you had was the result of domestic violence, you're afraid that information is going to get out, and so you tell the doctor, oh, well, I actually got this injury in some other way. You might not get the kind of medical treatment that you really need to address the specific injury that you have because you've misled your doctor about how that injury occurred. So it's not just about this sort of general value that victims place on protecting their privacy, but it's also really specifically because of the understanding that in order to get specific services from particular service providers, including advocates, that that kind of level of honesty is really necessary, and that there's a recognition that that can't happen unless privilege is protected.
That's great. And I also just think it's really, I mean, the thing for me being an advocate when this came out was just helpful to it sort of be elevated to that level that, you know, the law is acknowledging that you all play a really important role in survivors' lives. And that for me was just a really, you know, we described it when privilege first came is that we've always had the cake of confidentiality and privilege is the icing on the cake. And that just having that extra protection, an extra acknowledgement that it is really important that we, you know, keep survivors' information confidential, and that is paramount to us providing the best services to them, was just really helpful and kind of gratifying to me to hear. I did want to say that we're going to talk about this a little bit later too, but you know, VAWA, the new VAWA, has also really, really prioritized client confidentiality, and that they kind of have taken on an even stronger protection. So we'll talk more about that. But if you've been hearing a little bit about, you know, well, the new VAWA says this, we will talk about that. But it definitely puts a very high prioritization on keeping confidentiality, and really that you only make a report in extreme cases. So we'll talk about when that is.
So some of these are exceptions and some of these are examples of when privilege does not apply. But the most clear example of a situation where you would not be obligated to continue to maintain confidentiality is if your client gives you a waiver, or in other words, gives you specific permission to disclose particular information. And typically that disclosure is going to need to be specific in the sense of having specificity with regard to what information is disclosed, to whom you are disclosing it or for what purpose you're disclosing it, and how long you're authorized to make that disclosure. VAWA, for example, has a bunch of limitations on if you have your client sign a release of information form, what that has to look like, what kind of provisions are required in that kind of agreement. So if your client does sign a waiver to allow you to disclose certain information, one of the things that's required by VAWA is that it be time limited. It can't be just sort of a permanent waiver. It also has to be usually pretty specific to what information the client is willing to have you disclose. So that's an example where the privilege applies to the information that's at issue. So whatever the client has told you, that information is privileged, but they are essentially saying that despite the fact that it's privileged, despite the fact that you have the right to not testify about this stuff, they're going to allow you to do that. And I like to think of privilege and privileged information as being like property, like physical property, something you own, or something, I shouldn't say that you own, something that the victim owns or a survivor. So if your client provides you with confidential information that is privileged, that client, in my view, is essentially loaning you that information as though it was a physical thing. Now, that means that you have the right to have that information as long as the client has continued to give you that permission. But you do not have the right to give that object that belongs to the client to somebody else without their consent or without a waiver on their part. And specifically, if you're going to give somebody the thing that your client loaned you, you have to get the details. You need to find out, is there anyone that you don't want me to loan your car to? Is there, but is it important that the car that I'm loaning you not be driven out of town? How long can I borrow it? All of these sorts of factors that would apply when you're talking about the loan of personal property similarly apply in the context of privilege. So I think it's useful to think about it both in terms of reminding you that you need to be cognizant of all of those kinds of specifications and limitations that should happen anytime that there's going to be a waiver, but also to clarify the sort of at the conceptual level that the information, even though it's in your possession, still belongs to the client. It's not something that you own just because you're the one that wrote it down in your records. The information itself is the client's. And so I think when you think about it that way, it's easier to remember that in the context of waiver, there's only one person who can waive privilege. There's only one person who can consent to the disclosure of information, and that's the client. So if you were to, for example, get a subpoena for a deposition, and the defense attorney wanted you to come in and be deposed, you don't have the right to give permission. It still belongs to the client, and so it's up to the client and only the client. That can get a little bit more complicated in the context of juveniles. I'm sure their person, I think, helps to remember that that there are not other people that can intervene and waive that privilege on your client's behalf. One of the other exceptions that's written into the statute directly is that if your client was to disclose that your client was suicidal or homicidal, you, under Washington law, have the right to disclose that information to protect the person, whether it's to protect your client from suicide or protect the abuser that your client has threatened to go after with a baseball bat. You, under Washington law, would have the right to do that. Now, VAWA changes things a bit, so we'll talk about that when we get to VAWA. But the important thing here to remember is that this is a discretionary. The discloses that they're going to go after the opposing abuser with a baseball bat. You are not legally obligated to tell anybody that a child has been abused or neglected. You must make a report to either Child Protective Services or law enforcement. That is not discretionary. It is something that under Washington law is mandated, and so it is consistent with VAWA, and it is something that is the only really clear, definite, absolute exception to privilege other than the consent of the client.
Yes. I did get a couple of questions here, and I think hopefully you all saw the answers. But the first question was, what is VAWA? I realize we probably should have said that. So it's the Violence Against Women Act, and it was newly authorized in 2012. And I want you to all know about VAWA because it's, it was a huge fight and it was a huge victory that we got it passed, but we certainly have more to do. So it'll come up again, I'm sure, when we have to reauthorize it again. So we'll want you to be staying tuned to that. And then another question was, is a client somebody who's under 18? And the answer is yes. So in Washington, you can work as a domestic violence or sexual assault advocate with teens 13 and over without the consent of their parents, and their information can be kept confidential. At the end of this, we have some resources that we'll share, one of which is kind of a at a glance look at how to serve teens, and so I'll share that with you again. And then the other thing is, somebody asked if we will be giving out the PowerPoint, and the answer is yes, we will be giving out the PowerPoint. All of these, everything you see today, you will have access to. And then somebody's just asking right now, can you give the definition of reasonable cause?
I can't specifically, but that's really because there isn't a definition. And I'm going to be giving you that answer a lot today. It's a frustrating answer to give and a frustrating one to receive. But the bottom line is that a lot of the law related to confidentiality in general, a lot of the law related to juvenile rights, and a lot of the law related to less so the issue of CPS mandatory reporting, but sort of the general context of confidentiality and privacy and what all those rights mean. The law is very unclear when it comes to a lot of that stuff. And that's, coming from the perspective of a lawyer, I always hate having to say that, but the truth is that, the legislature does its best, for what it's worth, to address issues. But I think that there are also times when the legislature chooses to leave things a little bit unclear, and they do so because they recognize that they can't, predict every possible scenario, but also because having a little bit of flexibility and a little bit of discretion in the law is really important and useful to make sure that fairness ends up happening. So reasonable cause, I think, when you're determining whether or not you have reasonable cause specifically to believe that a child has been abused or neglected, that is really up to you. I think the use of reasonable can mean one of two things in the law. Usually you can have a subjectively reasonable belief. So that is based on your knowledge, your experience, your understanding of the situation, what you believe. But reasonable can also be interpreted in an objective way. So the way that that's usually framed is, would an ordinary person with, generally, basically an understanding of the situation, what would they do? So I think you can think about it both in terms of from your personal perspective and also thinking about generally, what would somebody at DCFS think if they heard this factual allegation? What would, my next door neighbor who happens to be a cop, what do I think they would think? So you can kind of work through in your head what, your personal preference is as far as whether you want to decide that you have reasonable cause. But it's also useful to kind of, as a thought exercise, consider whether other people who, are in a position to be able to assess this kind of issue, whether they would believe it was reasonable. In determining whether it's reasonable, I think it's really important to understand that a lot of times that really comes down almost entirely to the issue of credibility. And in court, the issue of credibility usually comes up as a way of undermining or harming our clients. But it's also something that not just a jury or a judge assesses, but that you have to assess. So, if you hear allegations that seem completely ridiculous, for example, the abusive parent comes in and makes a bunch of allegations against your client that have no basis in any evidence that you've seen and seem to be both illogical and fabricated, that is an allegation of abuse or neglect, but you, based on the context, you have good reason to believe that this person is actually making it up in order to hurt your client. So in that sort of a situation, I think it's pretty reasonable to say if there is an allegation of abuse or neglect, but I do not have reasonable cause to believe that it is true. In contrast, if a child discloses to you that they're being abused or neglected, unless they're telling you that it was done by space aliens or something like that, that is probably going to be pretty credible, and therefore you're going to have a lot of other factors weighing against it for you to be able to argue, reasonably that you don't have reasonable cause to believe the allegation. So I know that's not a clear-cut answer, but I think the use your best judgment is really what it means.
Yeah. And we're having a couple of questions about some more specifics around mandated reporting, which I will attempt to address some of them. But the one thing I will say is that I'm hoping that this conversation is more about teens, because that is certainly more of where I feel like my expertise is around this. But there is a question about mandated reporting that's more general that I'm happy to answer. And then when we kind of cover the basics, we're really going to go through it quickly because there are quite a few resources, again, that I'll connect you with at the end. But there's just a lot of information about mandated reporting that's available, so I feel like you can get that other places. And I really feel like it's worth it to have those conversations in your program very regularly. Like, what are your practices? How do you operate? So the question that we got, though, was, I work in a shelter. If another client comes to you and tells you they heard another client hitting their child, but you did not witness it yourself, does the advocate report it even though it was third party, or does it need to be witnessed firsthand? So my answer to that, my first answer would be, again, mandated reporting is one tool in our toolbox, so I would use my other advocacy skills first, which would be to talk directly with the client and have a conversation and see what's going on. I think that communal living is really hard, and I think that there's more, there's always other things going on, and so I think I personally would rather have a relationship with the folks that I'm working with that enables me to have a pretty open conversation with them and check in with them. So my preference in terms of, I feel like my obligations for reporting is that it's that I feel like there's reasonable cause, and that would be more than hearing it from another party. But certainly I would like to, have more of an, I hate to say the word investigation, but I would want to know more about the situation. And talk with the kids and see what's going on. The beauty of being in shelter with folks often is that you have more access and you get to see how folks are doing, and you get to actually talk with the kids. So that would be my my first order of business would be certainly to just use my other advocacy skills and chat with the client who is being accused.
And that's a good idea, not just to clarify whether you have reasonable cause to believe it, but also to really figure out what's going on. So in Washington, some forms of corporal punishment are legal. Mm-hmm. So if you're talking about, a young teenager, and the parent is spanking them, it may very well be that that's something that's specifically defined as legal under the law and defined as not being abuse. So unless you do get to talk to the client, talk to the teenager, you're really not going to have any clear sense of whether what the allegations are rise to the level of abuse, let alone whether you have reasonable cause to believe them.
Right. And we may have lots of feelings and opinions about, whether or not that's a good parenting strategy. And I think that you're certainly welcome to talk with folks about that. And there certainly are programs that have other expectations around how people are treated when they're staying in shelter, and all of those, really up to your program. But the bottom line is that, we really want to preserve our relationships with our clients and stay connected to them. That is actually going to serve everybody better. And so the first, hearing something and immediately going to, I have to be a mandated reporter and have this, call CPS, that's not necessarily going to be a relationship builder, right? So does it mean that you don't report if you find out, but there's also lots of other ways to meet that reporting requirement that doesn't include you doing it without the client's knowledge. So, and we'll talk more about that. But again, we're really going to cover this very quickly. So if you want more information on mandated reporting, please do let me know. That's something certainly at the Coalition we have lots of resources on, and there are lots of other people out in the communities that have great resources as well that we can connect you with. There we go. Okay, so this is basically the same thing that we just had put in that third exception bullet, but this is really what the law says. No. And the other thing I think is interesting about this is that it says CPS, so it's Child Protective Services or law enforcement. So it's really, that's I think an interesting thing. We'll address that more as the teen comes up because it does matter in teens, but really you're meeting your obligation if you report to either one of those entities. So do you want to
Sure.
this one?
So I think this is to some extent what we've been talking about, but to just sort of streamline it a little bit, I think that there's a pretty clear process that you can go through when there's an allegation that's raised that makes you wonder whether or not you need to make a mandatory report. So as in the example that we were just talking about with somebody at a shelter who may have hit one of her children, so that issue that I raised really gets to this first one. So determine whether the facts that are alleged constitute child abuse if true. Okay, so again, if the parent was using reasonable spanking techniques based on what the law says is reasonable, that would not constitute child abuse even if true. But if the parent hit the teenager with a closed fist in the face, that would definitely, if true, constitute child abuse. So figuring out exactly what the factual allegations are is the most important first step. Then after that, then you have to decide whether you have reasonable cause to believe that those allegations are true. And again, this is where you really have to evaluate credibility. Does the person from the shelter who reported it, have some sort of vested interest in getting the person that they reported on kicked out of the shelter? Is there some other personality conflict going on that's leading them to do this? In the example of, when it's the abuser, him or herself, who makes the allegations, are those allegations credible? And that can be based on all sorts of factors, ranging from, the context in which you hear the allegations. Is it in the middle of a custody battle that the abuser is making the allegations? As well as the specifics of the allegations. Are they claiming a factual scenario that is not very logical? So maybe engaging in some sort of sexual abuse with a teenager who would be old enough to identify it as problematic, that you might make sense if it was happening to a 3-year-old who doesn't know that, daddy's not supposed to touch her like that during taking a bath. But, realistically, is the parent going to be touching a teenager like that during the bath? No. So again, in that situation, you may not have reasonable cause to believe the allegation. Even if it was true, it would constitute child abuse. So then those are really the two determinations you have to make. If you're not sure, then there are a lot of others within your programs and within the coalition that are experts on this and that can really help you make that decision. But then the bottom line is that if you do believe that what the allegations describe rise to the level of abuse or neglect, and if you find that you have reasonable cause to believe they're true, then you have 48 hours at most to report it. That gives you a little bit of a window in which you can engage in the kind of advocacy techniques that Eileen was talking about, with talking to the client and that sort of thing. But there is that hard and fast deadline, so it is important to be conscientious about that particular deadline.
Yeah, and a lot of programs, I think, have policies and procedures that help that, so that if you're going to make a report, you need to check in with a supervisor and just chat with them about it, or, there's lots of different ways to make that work and make sure that advocates have the support they need to make those decisions and then follow through. And again, we'll talk about best practices for making a report, or making a report isn't just picking up the phone and calling it. Hopefully, it's really more of an engaged process with the survivor. It's pretty hard to click. I couldn't resist a Ghostbusters thing here. Who are you going to call? It's been, what was it? I think it was 40 years. No, wait, I don't know, some crazy amount of years. Was it 40? I'm not 40. That doesn't make any sense. Maybe it was 20 years. Anyway, it is old, but I still love it. So you can really report to either CPS or law enforcement. Again, your program might have policies that dictate which one. It's super helpful to have really great relationships with both, to sort of walk through that process with the survivor and really kind of do it together. Best practice again, and we'll talk, there's, after we talk about the teen dating violence, there's information that makes more sense to report to one of these, so we'll cover that. But bottom line is you can report to either and you fulfill your reporting duty. So teen dating violence. So we're going to move on from just basic mandated reporting and really think about whether or not peer-on-peer dating violence is a mandated report. That's what I started with, over 2 years ago when I was starting to think about how to support programs to do more work with young people. There were two things that kind of kept coming up as barriers for people. One was, can I even serve a teen? Are they even eligible for our services? Are we legally allowed to? Last year we did address that, and hopefully, it is clear to most people now that you can serve without the consent of their parents a teenager who's 13 and above. There are a few specific things that, in terms of records, that are a little bit different, but again, I'll give you that sheet that kind of clarifies all of that. But the bottom line is you can absolutely serve teens in your programs. I know that a lot of you were already doing that if they were teens who were children of the survivors you're working with, but you can also serve teens who are coming to your services for help with their own relationship. So that hopefully helps. The other thing that kept coming up was, okay, then if a teen tells me that she's being abused by her boyfriend who's the same age as her, do I have to report that? Because the way that our law is written, it says abuse by any person, so it's really complicated. So here's what I found, is that the law is really unclear about whether peer-on-peer dating violence is a mandated report. It doesn't actually say so one way or the other. So we're going to share with you sort of our process for how we came to our answers. So we spoke with experts. I have spent the last year really talking with folks, I mean more than that, but in a really targeted way. I've spent the last year talking with representatives from DSHS, Children's Administration staff, from law enforcement, from advocates, from national TA providers. You know, really, I've just really tried to cover my bases because I kept thinking, I was very naive, I kept thinking if I ask the right person, they'll tell me what the answer is. I didn't really realize how the law works, but that's not what happened. What happened was most people that I called said, oh, that's a really good question. I don't know.
The same day?
So I just heard a sound. That's so interesting. I'm just going to see if everybody's mute. Yeah, that was, wow. Maybe Ghostbusters just came. Oh, I hear it again. Hold on one second. I'm just going to try and make sure.
Muted. Unmuted. Muted. Unmuted.
Okay. Hopefully, all right, that was very interesting. It was our Ghostbusters reference that it came to haunt us. Somebody, by the way, clarified that it was 30 years ago. So I knew it was something. I just lost my mind for a second. Anyway, so when we talked with folks, they were most often said, wow, that's a really good question, or I've never thought about that before, or honestly, I can't imagine it's a mandated report. And most people actually said, talked about the history of the law being written, and it really just became clear that in most cases people really didn't think that teen dating violence would trigger an advocate's mandated reporting duties. Part of the reason of that, especially for the Children's Administration, is that if you look at how their structure is, it's really more about protecting kids from the people who are in charge, supposed to be taking care of them. So all of their stuff is written as parents or guardians or caregivers. What's interesting is that our abuse, the law about abuse does say any person. It doesn't say parent or caregiver, versus neglect does say parent or caregiver. So there's definitely a gray area, and it's very unclear. And when I spoke with representatives from law enforcement and DSHS, they all said, I just can't imagine. I should say CPS in general said, I really can't imagine us acting on this. There is a difference in, I think probably regionally or even locally, whether or not if CPS got a report of teen dating violence, whether or not they would alert law enforcement, but there's not necessarily a statewide policy on that. And it seems like it's happening in really different ways across the state. So ultimately, our conclusion was that in general, in most cases, teen dating violence won't trigger an advocate's mandated reporting duties. And we'll go into more of what that actually looks like. But again, when we say teen dating violence, in particular in this case, we're talking about peers who are of similar ages who are dating each other and are having, some whatever we would call teen dating violence. And then we'll talk more specifically about what is the cut, what do you have to kind of get over, what's the hump in order for it to be a mandated report. So this is that hump, which is that if you reasonably believe your client experienced serious physical injury or abuse resulting in injury, and if it's ongoing, you should probably report it. And so this is, again, using your best judgment. This is our interpretation here at Wiscative. Your programs are free to figure out your own way of sort of making decisions in this case. You have your own attorneys that you can consult with. But we feel like it is in keeping with the law that if there was a physical abuse resulting in actual injury, that you should report it. And my feeling is that in the case of teen dating violence, you should report to law enforcement because it's really not under the purview of CPS. So that is my suggestion. We'll talk about the implications of that decision because I think that it means that you have to have a really strong relationship with your law enforcement if you're going to start opening this can of worms where they respond to teens who are in violent relationships. I just feel like there's a lot that needs to happen with that. But ultimately, If you feel like the client that you're working with experienced serious abuse resulting in actual injury, you should report it to law enforcement.
And I think in that context, it's useful to think about, well, what are the potential consequences of reporting it, even if I don't 100% have to? And leaving aside VAWA for a second, which we'll get to. In theory, the reason that there are basically two reasons that you don't make a mandatory report if you don't actually have to. One being that you're going to damage your relationship with your client, and secondly, that in theory, you would face liability, legal liability, for disclosing information that is confidential under the law, and therefore violating the law by disclosing that confidential information unnecessarily. But the important thing to remember as far as all of that is concerned is that the legal standard that you're going to be held to in that sort of a situation is, did you act in good faith? So if you make a mandatory report and believing that you did need to make that mandatory report and that your client, maybe was seriously injured and is in significant risk of further injury, it is pretty easy to justify the position that you were acting in good faith. And so if somehow a client was to come back later and try to sue you because you disclosed this information by making a mandatory report and you should have kept it confidential, all you have to be able to do is to show that you acted in good faith, that you did your best to figure out what your responsibilities were, and that you tried to act in your client's best interest. And so I mention that not because I want to scare you, but by raising the issue of legal liability, but actually the opposite, that I want to make sure you understand that that the laws protecting confidentiality, while important, don't really have a lot of teeth to them. And specifically in the context of advocates, as long as you're doing your best job as an advocate that you can, the risks to you are, almost nothing. So as far as legal liability is concerned. That is sort of the context in which we're saying, if there are these really serious concerns and you feel like your client is at this ongoing risk, that's going to affect whether you have a good faith belief or not that really this is something that needs to be reported.
Yeah. So there's been a lot of questions about this, which doesn't surprise me. I mean, it's a lot. So I'm just going to try and cover some of them. So Susie asked if it was, so CPS is only family involved. So would dating violence resulting in injury be reportable to CPS? I mean, technically you are meeting your mandatory reporting obligations by reporting to CPS. In my conversations with folks at CPS, it really does not seem like it's not their purview. They don't have the tools or really the mandate to deal with that. And so in some jurisdictions, it sounds like maybe they would report to law enforcement. But because CPS has also been sort of decentralized, or centralized, not decentralized, that might also be hard for them to connect with the right people. So if you feel like, so my feeling is if you're going to make a mandated report, it should be meaningful. That's just my own feeling about it. And so I would suggest reporting to law enforcement. There's no reason why you can't report it to CPS, but it's sort of an ineffective report. And again, all of these things, when you report, you can certainly engage with a survivor, and that is what best practice would be, certainly. So somebody asked, does it mean it would be okay for advocates to report to law enforcement without the client's consent? In this case, yes, it would, but my advocacy perspective would be, but wouldn't it be better if you reported it with them, or they reported it and you were sitting there? So certainly you can. Again, there's like sort of this like, how do you approach this? Do you approach this like, what is the law? What are my legal requirements? Or what is my best advocacy? And I think it's really helpful if you can sort of wear both of those hats at the same time and merge them. So if you can, the best advocacy perspective would be to say, hey, Emily, I'm really concerned about what's going on with you. It seems like, this is really dangerous, and I'm nervous that it's going to happen again. I feel like maybe we need to get law enforcement involved. And, Emily might freak out, right? And then we can talk about, what are your concerns? What are you nervous about? Is there a way that we can do this in a way that makes you feel safer? Is there a specific officer? A lot of times, if she goes to school, there's like a school resource officer. Do you feel like that's a trustworthy person? Can we talk with that person? And figure it out. That, I think, is a much better advocacy strategy than Emily saying, hey, this is going on, and say, oh my gosh, whoop, 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 whoop. I have to, report to the police. See you later. Not that you all are doing that. obviously. I don't think you're doing that. But, you know, I mean, so there's a long distance between, you know, the alarms going off and sort of figuring it out together. So that, I think, is best practice.
And given that it is probably law enforcement, you know, one of the things to consider is, you know, is the sort of thing that's being disclosed the sort of thing that law enforcement would actually care about? You know, one of the reasons that it sounded to me like some of the law enforcement people that Eileen spoke with were not real interested in addressing this issue or getting mandatory reports is that this, you know, they perceive teen dating violence as being something that, you know, that the abuse that's happening, you know, may not be likely to involve serious injuries. You know, it may be, you know, kind of, you know, shoving somebody with your shoulders into the locker or, you know, little kinds of intimidation or sort of bullying related behavior that would never get charged as a crime. So thinking in terms of, you know, is this something that law enforcement could actually investigate and file charges for, that may influence your consideration of whether what you're talking about is serious enough to warrant making a mandatory report.
Right. Somebody else mentioned that they serve teens and that one of the issues that they've sort of come across is that it's hard that they've engaged with the teens' parents, and sometimes that's good and sometimes that's not so good. And again, I think that this is really, it's so hard. I mean, let's be honest, you know, teens are in a really different developmental stage, and so they're naturally going to sort of be opposed to being more connected with their parents or being more connected with folks that they don't feel like have their best interest or, you know, whatever it is. But ultimately, the best thing that advocates can often do is help people see who are the supportive people in your life and who are the folks that we can really get support for you from. And that sometimes that's a mom, sometimes it is not, right? Sometimes it's going to be somebody that that you know, sometimes it's going to be somebody that the teen kind of wants to connect with and you can help facilitate that. But ultimately, again, all of our strategies of our best advocacy that we can use, right? And so part of some of our great strategies for advocacy is, you know, you have this great supportive aunt. I really want to figure out a way for you all to connect because that is going to be a more meaningful relationship that might actually carry her to safety in a different way than having her not connected. So hopefully that helps. I think I'm trying to see if there's any other. So Susie says something about, let's see. Yeah, I mean, this whole idea of the central intake machine at CPS is really hard to do meaningful advocacy when you leave the message. Even if you've done it all, what we would say is best practice. You all call together, you leave the message, and then you know, you don't get a call back until 3 days later, and she's no longer in your program, or you don't have a connection with her, or they call back and she's just not there because you didn't have a meeting. That is really different, and that's a different landscape than sort of what we're saying best practices is, which is when you can actually like get the person on the phone immediately and kind of deal with it. That's really hard. I don't have some great uplifting thoughts about that. The one thing I will say is that actually is taken out of the equation if you're talking about peer-on-peer dating violence because it makes more sense to connect with your local law enforcement. So you do have the advantage there where you could actually even go in and sit face-to-face or you could make the call together and you'll actually like get a person. So that is one advantage. You know, again, I think there's a lot of work that we need to do with law enforcement to make that a positive experience. Some communities are already there where they have great relationships and the cops totally get how to work with teens and they're on it. Some other communities, not so much. So, but I do think in terms of the central intake, at least that is not an issue, hopefully, that comes up as much for you with this particular thing. But in terms of general CPS reporting, I hear you, and I'm in solidarity with you. That's all I can really do on that. Okay, let's see. All right, so this is where we're like, ooh, the water was sort of clear. Now we're going to throw some mud into it.
So bringing federal law into the situation makes things both clearer and less clear at the same time. So VAWA is a federal law, and generally speaking, you are obligated to follow both state and federal law. There are a lot of different areas or issues where both federal law and state law address the issue. So, for example, in the context of HIPAA, which healthcare privacy, there's a federal law, HIPAA, protecting your medical information. And then HIPAA also says, and states may enact laws, and people have to follow those laws too, as long as they're equally strong or stronger than HIPAA. So it basically sets a floor or a minimum for what the protections are, and then states have the ability to create more protections. In this context, VAWA sort of works in the opposite way by saying that essentially if you have any discretion, if it's a maybe as to whether or not you're going to file a mandatory report, if it's a gray area, if you're not clearly required, under those sorts of circumstances, VAWA says that if your program gets VAWA funding, so this doesn't apply to people who have programs that don't get any VAWA funding, but if your program gets VAWA funding, it says if it does fall into a gray area, you cannot violate your client's confidentiality without their permission. So going back to when we were talking about the exceptions to privilege, that second exception that we mentioned was if your client discloses that they are suicidal or homicidal, that you may disclose that in order to prevent injury to somebody. Well, under VAWA, that word may, because it gives you the discretion to either do it or not do it, depending on what you feel like, VAWA says we're taking away that discretion. Because it's up to you, we say the answer is no, you can't do it.
Sorry, there actually just was a clarification. Oh. Well, I don't know if I maybe I should have communicated this to Emily. They actually just clarified that, again, you really have to have you have to meet the second bullet point that you really believe you must report it, but that you actually can, that they're saying that in this case they're sort of allowing Washington to continue with their wording, if they feel like somebody is in danger, that they want you to prioritize confidentiality and only do it in extreme circumstances. That's basically their sort of new take on it.
That's interesting because that seems very contradictory to me with the actual text of VAWA. But again, this is a good example of the fact that the law is oftentimes as clear as mud, and that what the law actually says and what the law means can oftentimes be two different things. So leaving aside that example, let's consider the example of a subpoena. A subpoena is not the same as a court order. As many of you hopefully know, a subpoena is just a document signed by an attorney. It has no more legal force than an attorney has. Even though a subpoena says the state of Washington commands you to, give us some records or appear for a deposition or to testify at trial, really what that is that's an attorney telling you, I'm demanding that you do that. But a lot of times attorneys screw up, or they do things that are intentionally overreaching because they want to help their client, and so they really push the boundaries and sometimes go too far. So you may get subpoenas that are not legal, that are actually unlawful subpoenas. That's not at all unusual, I would say. So one of the things that VAWA, this provision of VAWA would mean is that the fact that you get a subpoena does not necessarily mean under the law that you are obligated to do what that subpoena says. So instead, in those cases, what you should be doing is objecting and making the attorney go to court and get a court order signed by a judge that says, yes, advocate, you are required, in fact, to appear for this deposition. So that's an example, again, where it's not that it's discretionary, but that because it's only a subpoena, it's not a clear mandate under the law because it could be in violation of the law. So the only way that you know for certain that you are absolutely required to violate your client's confidentiality in that situation is if a judge tells you that you have to. So that apparently is a better example than the other one.
Well, and Logan, I think, is actually, she's going to talk later, and she was on that call, so she can weigh in for us too if she wants. But somebody's asking, where does that second bullet point come from? And was this your interpretation, or was this actually the language that you kind of took?
The second exception, wait a minute.
I'm not sure. Maybe, Jennifer, are you talking about the exception bullet point or the bullet point on this page? That might be helpful to...
No, okay. So I think if what you're asking about is the one on this page, then yeah, I mean those aren't the exact words. It's not a direct quotation, but that is what VAWA says. It says if your client gives you permission, then there's no issue. You don't have to worry about whether you're legally obligated to disclose something. If your client gives you permission, that's a waiver, so there's no problem. In the alternative, if you don't have your client's permission, and so disclosing would be a violation of your client's wishes in terms of protecting his or her confidentiality, then you have to have this clear mandate, and that would need to be, you know, in the case of trial testimony, for example, from a judge, not from just an attorney subpoena, or in any other case where you think it's sort of ambiguous, you're not really sure whether or not you're required to make a report, VAWA would say, no, you don't make a report unless the client consents.
Super clear, of course. So somebody's saying, should we get a release of information in making the report?
So that's a great question. The fact that you are legally obligated to make a report means that you do not have to have permission. It is essentially that sort of legal command overcomes your client's lack of consent. It means that your client doesn't have the right to, well, the client is still withholding consent, but that you do not have to follow what your client is telling you to do. So no, you don't need a release of information. But in terms of what Eileen was talking about in terms of advocacy best practices, where working with your client to have make sure your client understands why the report is important and why it might be beneficial. If your client is willing to sign a release of information, that would definitely be a better practice just in terms of improving your relationship with your client and also empowering them to make them feel that they are part of this process. This is not something that's being done you know, over their objections. It's being done with their participation.
Oh, that's great. And, you know, again, so we basically have just said this, but, you know, your job is to be the most effective advocate possible, and that doesn't go out the window because you're a mandated reporter, right? All of those things you can work together. And then it's really important, you know, again, in the document that we talk about serving teens, we talk about really being upfront about your duty to report, and this is for teens and for, you know, really anyone that you're working with, that folks should know what the expectations are around keeping their information confidential. And so I know that you all have a kind of a rap that you give anyway that says, you know, I'm mandated to report child abuse, or, you know, whatever it is that you're saying to folks. It should just be really clear, and you should be using those skills that you have at every stage to make sure that, you know, the survivor you're working with understands the process, gets support, and really is able to make the choices that they think are best for themselves. So, you know, none of that changes because of the fact that you're a mandated reporter. So, and really, you know, the takeaway for us, at least, is that, you know, what we recommend is that you use even an attorney, if you feel like you need to determine if your duty to report outweighs your duty to maintain confidentiality. And that really is the crux of the issue, is that we have lots of laws that govern that we are supposed to maintain confidentiality. And this is one limited exception. And does your duty to report outweigh that other duty that you have? So, you know, hopefully at least knowing all, you know, sort of all of this background that we've given you will help you to make those decisions. I also am sure that we've sort of muddied the waters enough. But, you know, I really feel like in most cases, when you hear about teen dating violence from a peer, you know, most cases it's not going to be a mandated report. It's not going to rise to that level. And so I think you can take some comfort in that. But then also know, if you're hearing about serious injury and you feel like it's ongoing, that really probably reporting is the best thing to do. Because again, you know, we started with we care, and we really want people to be, you know, have support and be safe and all of those other things. And so sometimes a report is the thing that needs to happen.
And consulting with your supervisors and program staff is important, not just to bring you some clarity, but also because if you determine that you do need to make a report and your client does not consent, and so you are violating your client's confidentiality, the fact that you consulted with other people who are in a position to have a really good perspective on this is additional evidence that you are acting in good faith, and that you're doing your best to figure out what your obligations are and which of these two competing obligations trumps in this particular situation. So that's a part of why it's good for this to be a conversation that happens with the client, but also with other people who you respect who know about this issue, just to make sure that it's clear to everybody, not just if there was going to be a lawsuit against you later on, but also to make it clear to your client that I didn't just make this report offhand, flippantly, or it wasn't just sort of frivolous, that I really went through this process of considering whether or not I had to, and I concluded that even though you don't want me to, and I understand that, and I understand that there are good reasons that you don't want me to, that unfortunately our best judgment as a program is that I do have to make this report. So I think it supports you both in terms of your potential legal liability, but also in terms of being able to justify the decision to your client.
Yeah. And then saying to them, and what can I do to support you through this, is really the key. So even when folks aren't happy with what you've done, you can still offer that you can figure out a way to continue to support them and figure out, safety planning and all of those other things. So here are some questions to consider that just can also help you kind of make that decision. And so, I don't know if we necessarily need to go through all of these, but they're pretty clear. They follow sort of what we've been talking about. But for me, the helpful one in particular is this idea about physical violence and if it caused injury. I mean, that's sort of a different switch. And then just the idea of, a lot of times we all minimize abusive behavior, but is the team doing that, and what are the safety implications of that? And then there's the issue of sexual contact, and actually Logan is going to weigh in about the more specifics, just so that you can sort of, it's much clearer around sexual assault, so she's going to weigh in on that. But did you want to add anything to this? Okay, so hopefully these questions will help you, and again, you'll get copies of this, so don't feel like you need to memorize it all. So let's see if we can unmute our friend. Oh, so somebody's asking if we can clarify what we mean by serious physical injury legally. We just had this conversation before the webinar started, but so could you clarify what you mean by serious physical injury legally speaking for recommended reporting with teen dating violence, and give us a few examples of legal serious injury?
Well, my flippant answer is no, because it's not defined in the law, but I'll try to do a little bit better than that. When I was looking into this issue, I ended up having to look at some other laws that have absolutely nothing to do with child abuse, things like L&I claims. When does something constitute an injury for L&I? And this is something that lawyers have to do a lot, is when the law is not specific about something, looking at other laws and trying to make the best analogy that you can, that to try to clarify as much as possible, what the issue is. But knowing that clearly the laws for L&I have no authority here, all you're doing is you're really, this is all about making a good faith attempt to assess the situation. So, so with that caveat in mind, injury, generally speaking, the statute doesn't say serious injury, it says injury. But I think in general, the way that the law seems to interpret injury in the physical sense, I say in the physical sense because stealing somebody's money is considered an injury or that sort of thing, but we're talking about physical abuse. In that context, I think that the line probably is best drawn between things that on one side either sort of don't leave marks or leave sort of minor marks like maybe a bruise, versus things that are done that actually cause an impairment of some sort. So if, for example, your teenage client's boyfriend grabbed her by the arm and grabbed her really hard and it caused some bruising on her arm, if you take injury and interpret it in the broadest possible way, arguably you could say that that is an injury. It's, broken blood vessels and so forth. But that would really be pushing it, and I think that there are very few law enforcement officers who would fail to laugh if you came in and said, I want you to arrest my client's boyfriend for, grabbing her arm. So I would say once it gets to the point where it's starting to impair that person, so if he, in grabbing the client's arm, he dislocates her shoulder or he sprains or breaks her arm, where she is then unable to use it in the way that she normally would. That's where we're crossing into the area of injury, where I think your duties as far as reporting are concerned become much more significant. And again, this gets to the question of, is this something that law enforcement is going to take seriously as an assault, as something that could potentially be criminally charged? If it's just something that is a mark that's going to be there for a day or two and then go away, probably not. If it's something that sends your client to the hospital, yeah, probably that is serious enough to be considered an injury.
Yeah, God forbid we give you like a
real answer.
It's so hard for me. I really wanted there to be like, but anyway, hopefully that's helpful. Okay, so I'm going to unmute Logan. Theoretically, Logan, can we hear you?
Hello.
Yay!
Good morning.
Good morning. Thanks for joining us.
Yeah, thanks so much for having me. I'm glad that we're doing this together because I know that, certainly sexual assault is sometimes going to come into the DV advocacy world and vice versa, so definitely glad to be a part of the conversation and help answer any questions on our end as well. So as Eileen said, we really kind of feel that, thankfully, there maybe is a little bit more clarity when it comes to peer-on-peer sexual violence and whether or not that's a mandated report. So this is language that has been shown previously this morning, and I'm sure most people are very familiar with this. The next slide, I think, yes. So you can see here, and I know that you mentioned this previously, Eileen, but I've kind of emphasized the by any person, and I think that this language helps us to be more focused on what has happened rather than who caused it. So as you've been talking about, do we have reasonable cause to believe that there is ongoing serious injury, or do we have reasonable cause to believe that sexual assault has occurred? And if the answer to that question is yes, then the who is less important, right? So as a mandated reporter, you are obligated to report sexual abuse against a child regardless of who the abuser is. So that could be a family member, it could be the neighbor, and it also could be a peer. Certainly, who the perpetrator is may impact whether or not it makes most sense for you to report it to CPS or to law enforcement, but it's not going to be the determining factor about whether or not you're going to make the report. So hopefully that's clear. The WAC that is kind of connected to our statute of abuse, and I think the important language in this WAC is that sexual abuse means committing or allowing to be committed any sexual offense against a child as defined in the criminal code. And so this gives us a bit more clear direction in terms of what really constitutes that abuse, where some of that clarity isn't always there when we're talking about peer-on-peer dating violence. So basically, what does this mean for you? It means that you're reporting any sexual offense as defined in the criminal code against a child. These are the details that someone has shared with me. I need to go compare that to the statute and really make that determination. That's really going beyond reasonable cause, right? So basically what we're just asking you to do is, based on your general understanding of our laws and your knowledge about sexual assault, is this considered to be sexual abuse, and is it harming a child's health, welfare, or safety? And after you then, make that determination, it's other people's responsibility to figure out if it is in fact a crime and how to proceed accordingly. So when we're talking about teens, we just wanted to kind of provide some tangible examples of what this could look like. So based on our statutes, a sexual offense could be an assault where the age of the victim and the age difference between the victim and the perpetrator automatically makes it a crime, regardless of consent. So, for example, we're talking about child molestation in the first, second, or third degree, as well as rape of a child in the first, second, or third degree. And the difference in these degrees are based on the age of the victim and the age difference between the victim and the perpetrator. So, for example, rape of a child in the second degree is if the victim is 12 or 13 and the perpetrator is at least 36 months older. So you can see in that situation where a sex offense has been committed and that victim may consider that perpetrator to be a peer. So that would be a great example of peer-on-peer violence that would definitely trigger your mandatory reporting obligation. Likewise, we're also talking about sexual offenses where some other element like force or lack of consent has made it a crime. And certainly there are some other statutes that would fall into this category, but I've just specifically kind of called out rape in the first, second, or third degree. So once again, it could be a situation where force is used and the victim and the perpetrator are of the same age, but the elements of what has occurred are still going to classify it as a sexual offense, and therefore it would be a mandated report. And I think what I, try to emphasize with advocates when I talk with them about this issue is kind of, as Eileen was saying, we really want to bring our advocacy skills to play here. So while it is important that we're armed with information when we're trying to make a decision about whether or not our obligation has been triggered, what we're doing before and after that decision is just as, if not more, important. And so from the get-go, we want to make sure that when we're talking with young people that we're really providing relevant examples about what is going to cause us to make that report. And so if we're talking with young people and our mandated reporting spiel is, I will have to make a report if someone hurts you, that's really not giving them adequate information to make an informed decision about what they're going to share with you, right? So we're not asking you to pull up the statutes and read those to folks that you're working with, but we certainly do want to be providing some of those more those examples that are more relevant to what violence may look like in young people's lives. So I hope that is pretty clear. Certainly happy to stay on the line here and take any questions as they come.
Yeah, that's great. I thank you so much. I definitely feel like it's clearer, so I appreciate that.
Well, so whereas my immediate reaction was to say, well, I can make this less clear for you. Specifically, there are a lot of different sex crime statutes. So, I've had a couple of cases where, for whatever reason, one of the charges that ended up getting filed was communicating with a minor for immoral purposes, right? Which, can mean anything or nothing. And it really seems to be used mostly to give prosecutors some flexibility. But there are a really wide range of sex offenses, so it's important to keep that in mind, and to keep in mind that not all of them are as clear-cut as, rape in the second degree or something like that. The other thing that this brought up that I think is really useful in terms of the reminder that you shouldn't be trying to think like a lawyer or a detective is to contrast the issue of reasonable cause with another term that you've probably heard in the context of law enforcement, which is probable cause, right? So unless law enforcement has probable cause, they can't arrest somebody. Unless the prosecutor has probable cause, they can't file criminal charges. That is a higher standard than reasonable cause. So they have to have pretty compelling evidence to support whatever it is that they're filing charges or going after the offender for. Reasonable cause is less than that. You don't have to have all evidence. You don't have to go out and investigate. It's good to have those kinds of conversations like we were talking about earlier, but because somebody had asked earlier about what reasonable cause means, one way to think about it is just to keep in mind that it is, I would say quite a bit less than probable cause.
That's great. So Logan, there is a question that says, so if I have a teen client over the age of 13 but younger than 18 who is raped and discloses it, we are mandated to report?
I mean, we're talking about anyone under the age of 18. I think, I'm trying to think about the different statutes, which, like I said, there's kind of a balance there. Mm-hmm. But if you have a minor who is disclosing rape, then yes, you are mandated to report that.
And so she clarified raped by a peer, but what I heard from you is that, you take the what, not the who, right? So the rape is the issue, so you report it regardless. And raped by a peer doesn't necessarily matter. Okay.
Right.
Thank you. Any other questions for Logan? And certainly, Logan, you're going to stay on, right, until the end?
Yeah.
Okay, yeah, and we're getting fairly close. But if you have any questions right now while we have Logan unmuted, although we're always happy to unmute you again. But write any questions. Okay, I know a lot of you are, it's really hard to think that there wouldn't be cases where you're hearing both about physical violence and you're also hearing about sexual violence. So I just think it's helpful to think about both of these together, but then also sometimes separate them because there's obviously different ways to deal with them. So thank you, Logan. Okay, we're going to move on. I think I have one more toolbox, yes. So, Logan was saying the same thing that I was around it's just one tool. And so, again, all your advocacy best practices. Okay, Susie asks, where does the preponderance of evidence fall in the range of reasonable cause and probable cause? That's for you, Emily.
So it's actually they're not analogous concepts. The preponderance of evidence relates to the burden of proof. So when you're in a civil trial or a civil hearing, the judge is making a ruling based on all of the evidence produced, who has satisfied the preponderance of the evidence standard. And preponderance of the evidence, for all of you non-lawyers, essentially means more likely than not. So unlike the criminal standard, which is beyond a reasonable doubt, which I always think of as being like, 98, 99%, preponderance of the evidence means more likely than not. So I think of that as being about 51%. Mm-hmm. So, but that's really about when all the evidence is in front of the court and has been produced, and the court is sifting through all that evidence, who has met what evidentiary burden. The issue of cause is long before you ever get to that stage, because you don't have all the evidence. As an advocate, what you're most likely basing your report on, if you're going to report, is simply a disclosure by somebody, or an allegation by somebody. And so you don't have the evidence to weigh to make any determination of preponderance or anything else. All that you can do is assess whether you reasonably believe that that allegation is true. And so it's much more based on your own sense and your own judgment, rather than an evaluation of evidence, because you know that you don't have the evidence.
So I think Logan, this is either Logan or Kelly, I'm not sure, but she says, to Elizabeth's question, always may be helpful to clarify our definition of child youth for advocacy purposes versus under 18 for legal purposes. I'm going to unmute you if you want to say more about what that means. Was that you, Logan, or is Kelly there with you too?
No, that was me. And I think I'm just kind of wondering if, based on the ages that she posed, if that might be a confusing factor for people. And this is something that I normally try to talk about when I talk about issues of consent for services and confidentiality. But just remembering the distinction that although, we at our agencies can make decisions to serve young people without parental consent, it doesn't mean that under the law they aren't still considered children. Mm-hmm. And so, even if we've decided that at our agency we're going to say that, a 13-year-old doesn't have to have their parents' consent to work with us, and we're going to hold their information confidential, that they're still a child under the law, and so the obligations that come along for children are still going to apply regardless of how we've chosen to serve them at our individual agencies. So I'm not sure if that was kind of at the crux of Elizabeth's question, but I think that's something that can often be confusing for folks.
Yeah, that's really helpful. Thank you. Okay, we're going to move on, but again, if you have more questions, definitely write them in and we'll get to them for sure. So these are some best practices, and here's the scoop. We have a whole thing on best practices for reporting child abuse in general that is, I think, it's more geared towards, when you're reporting a parent or a caregiver. And so I tried to pull out the best practices that we really think of that are in regards to teens or peer-on-peer dating violence. But certainly this is not an exhaustive list. So if you want the refresher on mandated reporting in general, again, I'll give you that at the end. So again, the thing really about best practices is just refer to your survivor-centered advocacy that you're already so great at doing. So all of these are really obvious to you, I'm sure. but just to pull them out, you know, again, if you can do it with the survivor as opposed to without their knowledge, and if you can talk to them before you make the report, do it together. It's always great. You know, assure them that you're going to be there for them throughout the process. So, you know, it's not like you're going to hand them off to law enforcement if you make a report. And that might be really important, especially for young people, to let them know, because they might have only seen, you know, there's a lot of things that they've seen on TV that make them, I mean, all of us think that it's going to go this certain way and that you're never going to be in their lives again. That might be really nerve-wracking and scary to them. Or also that they're maybe in the position where they're used to being left behind, right? And that this can really be an important relationship to kind of stick through, and so letting them know that you'll stay. You know, one of the things that advocates are great at is just validating how hard it is. And I think that it's, especially if you're making a report and they're not super happy about it, you know, I think it can be really helpful to validate that, like, that's really hard. And then finally helping them sort of anticipate the potential outcomes and consequences. So if they say to you, oh my gosh, if we call the police, you know, this horrible thing's going to happen, like really hold that as important and figure out ways of mitigating that. There's a question that came in. I'm going to wait just a second to answer it. So, the other thing that you can do is safety plans. So, like I just said in that case, but you know how to do this really well. You're already doing it. So just do it in regards to the report. Or if you don't make a report, you know, and you're hearing things that are concerning, but they haven't yet risen to that level, you know, obviously safety planning, it's, you know, we always say it's a process, not a product, and it's ongoing. So, you know, all those same things continue. There are DV protection orders that teens can get. The gist of that is that you can apply for one if you are 13 and up, if you have an adult or next friend do it with you, and then once you're 16 you can get one on your own, but the respondent always has to be over 16. So we have other information about that on our website and in other ways. So if you need more information about that, definitely email me and I can send that out. Okay, somebody asked, can we provide overnight shelter to a 13-year-old and older without parental consent? Couldn't that be harboring? So the answer is no. You cannot shelter people under 18. There are some exceptions to that, but for the most part, our advocacy services are available to young people 13 and up, but our sheltering services, you do need to be in either an emancipated minor or somebody over 18. So thank you for clarifying that. That is one of the exceptions. So ultimately, you know, we just want to stay connected. And this is what we say to friends and family. This is what we say to pretty much everybody about domestic violence, that those connections are the things that matter in terms of keeping people safe and getting them what they need. So we really, you know, one of the tools that you have in your toolbox is that ability to stay connected with people through really hard times. So I encourage you to do that.
And I think, you know, your clients can really benefit from your expertise in these situations, you know, in the sense that if you are going to have to make a report to law enforcement and your client isn't excited about it, you know, one of the things that you can do is talk to them about what, in your experience, you know, how law enforcement treats, you know, allegations. You know, do they, you know, is your local law enforcement the kind that is not going to file charges unless the victim wants to cooperate? You know, that seems to be the norm in most places. So, you know, you can reassure the client that there is this law that requires you to make a mandatory report, and you're going to need to do that, you know, hopefully with their help. But that they don't need to assume that that means that, you know, their boyfriend's going to go to jail or anything like that. The mandatory reporting is a legal duty, but it doesn't necessarily mean that any of the other consequences of, you know, making a report of abuse are likely to happen. And so I think, you know, you can maybe get your client's cooperation more easily by using your advocacy skills and your experience with the system, which they really don't have and really rely on you for, is your sort of knowledge of what local law enforcement is like, what local courts are like, in order to make sure that they really understand what the likely consequences of making a report are and aren't.
Yeah. Great. And one final question is, if someone is married and over 16, they can receive services because they are labeled an adult. Isn't this part of the law? Yes. So married teens are considered emancipated minors. So good job. You're doing it right. Okay, we're on the last section. Woo! So implications for advocacy. So there's just one slide about this, which, I joked that it's really not all teens all the time, but it is really helpful for us to sort of think about young people and how sort of incorporating that knowledge that we are going to serve teens or that we already are into the way that we do our work. So I think a key thing, especially in light of mandated reporting, is to really work with your local law enforcement agency on issues specific to teens. So the more that you can relate to them about what teens are going through and how they can sort of deal with them in a helpful way, I really encourage you to do that. One way of doing that is to do In Their Shoes. There's lots of other things that you all have access to. I just know that all programs have that, so that's an easy thing for you to do. Just really engaging with them as much as you can about how to kind of be their best selves, their best law enforcement officer selves. And part of that might be, some of you might be fortunate that you have school resource officers. I've heard from a lot of folks around the state that they are tremendous resources and they have great relationships with them. So hopefully that is the case for you in your community. I know that sometimes that isn't the case, but really being as connected as possible to those folks is really helpful. And then finally, in terms of making your program really accessible and great for teens to go to, solidify your policies. So, if you have, there might be some policies that you have that inadvertently make it really difficult to serve teens. Susie just asked a really good question. Sorry, I just got distracted. So anyway, so I think that there's a lot, and again, there's guidance in one of those materials that we can connect you with that has sort of like what your policies should include. Did you have anything more about implications before we sort of address this other question? Okay.
Okay. So yeah. So Susie's question was, definitely get the prize for the stumpers today. If a 16-year-old is married and therefore is considered as an adult for some purposes, do mandatory reporting laws still apply? Because for those purposes, the teen is not considered a child anymore. I cannot give you a definitive answer for this. I would need to spend a little time researching, but my sense would be that getting married does not create adult status. That adult is defined as 18 or older, a certain age. And so even if you're dealing with somebody who's an emancipated minor or something like that, they're still a minor. So there are different rules that may apply to them in some situations, but they are still categorically defined as a minor. And because they are still in that age range, I would say that the mandatory reporting laws probably do still apply to them. Now, again, when you're getting into these situations where you're kind of assessing, is this the sort of thing that law enforcement is going to be, or CPS is going to be interested in investigating, that may play some role in your analysis of that issue if the person is married and living an adult life and not, in the sort of position of a child that needs protection that CPS would be interested in. But if I had to give an answer right now, what I would say is as long as they're 17 and under, they are still minors and are still protected by the laws against child abuse.
I'm just going to ask Logan if you have anything to weigh in on that. That seems totally legit in my non-legal opinion. But I mean, it's like, because in the law, because I had to look at it in terms of sheltering, it clearly says a married child is considered an emancipated minor. So it still calls them a minor. So that makes sense to me. I'm going to unmute Logan real quick and just see if she has anything to weigh in on that. Logan, do you have any thoughts about that you want to add?
I definitely defer to Emily on that.
Okay. Sure.
I mean, I think in the context of sexual abuse, for example, you're not going to, unless you have parental consent to do it super young, I don't think you would ever have a scenario where you would have two married teenagers that would have a big enough age gap where one of the sexual assault laws that require a certain gap in ages between the two teens. So, it would probably not qualify as a sex crime unless there was force or that sort of thing. But, again, if there's force or that sort of thing used, then we are talking, and we're talking about a rape that's not based on age, then, you're probably getting more into the area of cases where law enforcement would potentially prosecute just irrespective of whether they're married. So, again, it's all really contextual, but I think probably even in the context of sexual assault that the safe practice would be to say, if you're 17 or younger, you're a minor, and the laws apply unless somebody tells me, points to me really specifically to a law that says otherwise.
Yeah. One other question we got was, can you give an example of a policy that would make it difficult to serve teens? One of the things that I often think about is just program policies that say you can't text clients, or that you can't be on Facebook or Tumblr or whatever it is, and a lot of times that's how young people want to communicate. So, one of the best practices I say for working with teens is to figure out, which is what we do often with survivors too, is how do you want to communicate with me, and making that happen. And sometimes there are policies that prevent us from doing it. So that's the one that kind of pops into my head. Or if you, if you're a very strict 9 to 5 type place, I mean, that can often pose barriers for kids that are in school and then have after-school jobs. So, but I would imagine that's for all survivors. So, Elizabeth's asking if anyone has a good policy on working with teens that they could share. Certainly, if you want to do that, feel free to send it to me, and then I can send it out with the email that has everything else. The other thing is one of the documents links to a model policy that Break the Cycle put out, Elizabeth, so that might just be helpful. You could base it on that. So I think actually that we're to the questions point, so we're all behaving very well. But yeah, does anybody have any other questions or comments? Especially while we have Emily, it's not often that we get to actually ask an attorney something. So don't ask too crazy questions, but if there are questions in line with this topic.
Well, and I could add that while technically you can't call me right now because I'm officially on leave, one of the things that my agency does is provide consultations for attorneys or advocates or whoever else are working with victims who want to ask a few questions about the law or brainstorm a little bit about these kinds of issues. So if it relates to a sexually abusive teen dating relationship, that would potentially be something that if you wanted to, you'd be welcome to contact our office. And I should say that even while I'm gone, we are still staffed by the other attorney. So that is another resource that you have available to you if after talking to your supervisors and other people in the coalition, maybe that you're still just not feeling real comfortable about what your responsibilities are. There are programs like ours that are available to be kind of a sounding board to help you work through those.
Great. So any other questions? I always say I'm really good at silence. Totally fine with silence. Okay, here's one. It says, if there was a relationship where the age gap made it a crime, but the relationship is over, do we still have to report it? Wow.
Okay, so technically speaking, mandatory reports pertain to abuse that has already occurred. They don't really pertain to threats of abuse. So in the sort of discussion of when you're dealing with a situation where it's kind of in a gray area and you're not sure whether or not you need to report it, in that context, I think taking into account whether there is an ongoing relationship and there is an ongoing risk to the client, that's a factor that isn't necessarily in the law, but that I'm suggesting that when you have a really close call and you're not sure which way to go, that is one factor that you could consider. But it is not a legal rule that there needs to be some sort of ongoing risk in order to make a mandatory report, or the flip side, that the lack of an ongoing risk means that you don't need to make a report. Now, in the context of the statute, which describes its statement of purpose as essentially protecting kids from their parents and their caregivers, that sort of presumes that there is this kind of ongoing relationship that, and part of the reason that you would be required to make a mandatory report is that there's this sort of legal assumption that unless somebody does make a report, that this person is going to be able to continue abusing the child in the future. So that's why I think it's a factor that you can consider when you're dealing with a gray area. But I would not. That's definitely not the first question that you should be asking. So I think, one of the other issues that you have to address just in general, not with teens, is, how far in the past do you look back, right? If you have an adult client who is abused by her own parents 20 years ago, you're not going to be making a mandatory report. If you have somebody who's just turned 18 and was abused, a couple weeks ago, right before they turned 18, and they're still living at home, maybe that would be a situation where there's enough risk that you should be thinking about talking to your client about whether a report should be made. So again, this is about as clear as mud, and can't really do anything to fix that, but I'm only suggesting that as a factor to really consider if you're kind of struggling with your good faith assessment of whether you have reasonable cause to believe that, abuse has occurred that's serious enough to warrant a report.
Yeah, and I don't feel like you need to make that in isolation. I mean, that's definitely, I would have a conversation with your supervisor or other program staff, certainly. Okay, any other questions? That would, yeah, I so appreciate you being here because I would have totally been stumped on that one. So. Okay, we still have we still have another couple chances, but here's some resources that I'll be sending out, and then a lot of these resources have other links. So there'll be live links on this PowerPoint, but then I'll also probably have them attached as well. The updated Serving Teens document is our website. It was really sad it crashed, so it's not currently up, but it'll be. So the new version, which will be updated to actually include information about mandated reporting, will go out with this email. So you will have that. It basically last year when it came out, it said mandated reporting is we don't really know. So this year at least it says, well, we know a little bit more. So so there's some helpful resources, and these are all things that we have put out at WSCDIV, but then again they link to other things, and there's also some links to that model policy that I had mentioned. So just a commercial real quick that we hope to see you soon. We have two big things coming up. One is the Refuse to Abuse 5K at Safeco Field, which is on July 19th. It's an evening run/walk. We need participants, and we also need volunteers. So you can actually, this will be a live link when you get it in the PowerPoint. And just so you know, I've had problems with this before, in order to access the links, you just have to have it in slideshow mode, and then you can click on it. So once it's in slideshow mode, you can click on it and register to either volunteer or participate right there. And the other really nice thing about this event is that it's a really happy event, which talks about domestic violence, which is not super normal, super often, so that we get that chance to do that. And the giveaway will be a Love Like This item, which is our new blog series that is sort of really geared towards teens. So if you're working with young people, I think it'd be a good thing to share with them. You can check that out on canyourrelate.org, our blog. And it's a really nice occasion to come together. You can wear your program t-shirts. You can get some good publicity for yourself, either by running, walking, or volunteering. And it's just a great time. So hopefully we'll see you there. The other thing that we have coming up in September is our conference, which is Ready, Set, Go. So we've been talking about beloved community the last couple of years, and now we feel like we're ready to sort of move forward with that. So there'll be lots of great workshops. There'll be some teen-focused workshops. Kiana and Rachel from New Beginnings will be doing one on doing middle school groups, which will be very, very exciting. And then Heather Corinna, who operates the website Scarletine, will be one of our keynotes, and she has a lot of great stuff to say about working and connecting with young people. So, and then there's lots of other things that you should come for. But if you're specifically interested in teens, there will be stuff for you. Just a reminder about the evals. Again, an eval will pop up when this webinar ends. Please do fill it out. We want to hear from you about what was helpful, what wasn't, and then also let us know who else was on the call with you. Okay, we're getting to almost the end where you won't have any more chances to ask questions. So here's my email. If you want to keep in touch, ask me any other questions. I'll be happy to try and get you answers or refer you to people who can help you out. And that's pretty much it. So any last thoughts? We'll give them, let's see, what time is it? It's 11:45. Ooh, we did very well. We'll give you another 20 seconds. And while you all are thinking about questions, I just want to thank Emily again. It was really great having you here. And just so appreciate your help and making me feel like mud is okay. So, all right, well, I think that's it. Thank you all, and please do keep in touch, and we will see you another time. All right, bye, y'all. Have a good day. Enjoy the sun.